Hang on. Okay. CICs, common interest communities, are akin to associations, right? Um, who knows what that acronym means? MCIOA. Nobody? I didn't either until I started researching for this class, right? MCIOA is the Minnesota Common Interest Ownership Act. And this is the law, the Minnesota statute that governs all of these rules that I'm going to talk about today with CICs. Okay. Our biggest thing as real estate agents with CICs is not to make the decision for the clients on whether or not the rules, the regulations, the bylaws are good, bad, and different. Our biggest thing is to make sure that the buyer client has all the information. That's our job, right? That's why our files get so thick because they have a lot of information. Okay. Just a quick overview. What's an association? It's a full legal entity that governs the common interest community on behalf of all unit owners. There's usually a board of some kind. Sometimes it's 3 people, sometimes it's 5 people, sometimes it's 18 people. It all depends on the governing documents. It owns and maintains the common element. Now, a lot of the time in northern Minnesota, we think of associations or common interest communities like old resorts where the seller or our client would own a cabin and maybe 10 feet around the cabin, depending on the rules. And then the association owns everything else. They own the lake shore, they own the tennis court, they own the pool, they own all of those things. And they're the ones that maintain it. Now, the money that they get is from all of the people who own in the association. They're charged monthly, depending on what they're charged, then depends on how much money they have in reserves. Okay. One of the things about associations is they can assess, just like a city or county government, they can assess a fee to your seller. And that can show up on the title work. So when you're filling out the taxes portion of the purchase agreement, you really want to make sure whether you're on your buyer side or sell side that those things are any deferred taxes, any set special assessments pending or levied, those pieces in the purchase agreements, that's what's going to govern any association assessments as well as city and county assessments. So as you're filling the purchase agreement out, make sure you're catching those things so that nobody ends up with a bill that they didn't expect at closing. Okay. Finances and reserves. So the goal of the association is to keep all of the finances in order for the association to do the maintenance and to have enough reserves for major repairs. Sometimes this can be a roof. I talked about we think of CICs as resorts. Sometimes they're a building where the association owns the whole building, you own your unit. Okay. All enclosed. So, but if that building needs a new roof and the roof costs $60,000, you as a buyer's agent need to make sure that company has, that association has enough money in their reserves to cover that roof. Otherwise, what the association will do is they will assess every person in that association for the cost of the roof, and then they'll be behind. Okay. Looking at the finances of an association is important. How many of you like to look at finances? That should be my first question. Nobody? No? No? P&Ls, reserve statements. Vern's like, no, I run businesses and I still don't like to look at them. Yeah.
Yeah.
When you're looking at associations things, either tell your buyers or you do it yourself to look at the finances and see if there's anything that jumps out. Okay. The other thing you can do is throw it into REMI, all of those wonderful documents into REMI, and REMI will parse it out. It's been really good, actually. Now, one of the other things that you hear about is a master association. How many of you have dealt with a master association for before? No? Okay. They're not that common up here in our area. They're more common in the cities. So a master association owns multiple associations. Okay. Each of those associations governs themselves. The master association essentially contracts with all those associations for a fee and then will take care of some things, whether it's golf course, the road, the pool, the gate, something. Okay. Bless you, Ashley. Um, so that's what a master association is. How do you know that a property is subject to MIOCA or whatever you say, MCIOA, Minnesota Common Interest Ownership Act? How do you know? Any idea? No? I think we all usually assume that anybody who says it's an association, it must be a part of this act, right? It must fall under these statutes, but that's not always true. Most of the time, it is going to fall under this act. Okay. If it's a condominium, a cooperative, a planned community, including townhomes, then it's going to fall under these statutes, under these rules. And then all of the documents that I'm going to talk about in a minute are required. Okay. The other option is that if they aren't a condominium, a cooperative, or planned community, they can elect as an association to fall under this statute. Okay. You're going to see that in the declaration, which is one of the documents that we'll go over, but you'll see that in the declaration. If the declaration says we follow these rules, then it falls under these rules. And then our statutory requirements of getting all of those documents together with the 10-day right of rescissions and the 10-day right to cancel, they all come into effect. Okay. Statutory exemptions, 2-unit planned communities with CIC plats. So if it's a planned community, but there's only 2 units in there, it doesn't have to fall under here unless they elect it, right? Obviously, detached single family homes. This one was interesting, and I didn't know this. Co-ops with leases under 20 years. Do any of you guys have co-ops in your area? Ashley does, yeah. Have you sold any co-ops like that before?
Yes, but it's been hard.
Has it? Okay, what's hard about
Yeah.
it?
I don't know. It's just, oh, we got to go through attorney for the closing. I mean, but they represent the resort and they knew a lot. So, I mean, she was pretty good. I mean, I don't know, just extra
It is.
and
Yep.
who to call and who has the paperwork. And then they just push it to the next person, like president versus the secretary versus, I don't know. It was
Okay.
okay, but it's just not my forte.
Right. It is a lot because you have to deal with the association as well as the co-op, as well as the lawyers, right? Because, like Ashley said, the co-op, you're buying a share,
Hmm.
right? You're not buying interest in real estate. You're buying a share in a company that has the real estate, and that share allows you certain rights.
Peyton,
Um,
isn't the one on the one with the mobile homes?
yep,
That's
Sunny Shores.
Sunny Shores.
Hmm.
And also there's one on Little Mantrap.
Oh, there is.
Yes.
Um,
And
okay.
I've dealt with both of those. And actually it's been fine. It's very quick because you're selling shares in a corporation and
Hmm.
there's no title search.
Yep, it can be faster. Yep,
Yeah.
absolutely.
What
So
about,
now, yep.
I have a question. So we have one up on Little White, or it's Little Pine and the Whitefish Chain, and I've never gotten into showing these things, but I happened to do it just this weekend. I showed some of those, and it's one where you get shares. But like, how do you even write up a purchase agreement? Like, what do you use? Because and then they have, like some, it's listed under land, and then they're listed under resident or single family, but it's like you don't own any real estate part, right?
Right.
So
You
it's like
don't
a personal property agreement.
You can use a personal property agreement. What we've done in the past is we just use a regular purchase agreement, and then the deed and in the deed area, we use the other option and we put share in this specific corporation. Yeah. Yeah, because and this is what becomes weird. Our real estate license does allow us to sell shares in co-ops, even though it's not real property, right?
I believe that went through the courts.
It did.
Okay.
We can, or we,
So we
yeah.
can. Yep. So we
Yeah.
can. Yeah. But you're right, Vern, it becomes a little hard because a lot of the things in the purchase agreement don't always apply, right?
Yeah.
Mm-hmm. Yeah. Christine, do you have a specific way that you would like our agents to use a purchase agreement for buying a co-op when they're representing the buyer?
No, just, yeah, like you said, just make sure that other box is checked and that you're saying that it shares. But
Mm-hmm.
it's something that, yeah, somebody should be on the forms committee to say, hey, maybe we need to have a separate purchase agreement for co-ops.
Right. For just shares. Yep.
But yeah, because I doubt they'll ever do it because we're rural Minnesota and it's not common
Right.
in
In the
the Twin
city.
Cities area, so why would they accommodate us rural
Mhm.
people?
They're
Yep.
looking for volunteers.
They are. You are correct. They're always looking for volunteers. What we could do is we could all get on the forms committee and just change all the forms to what we want them to be. We'll
Yeah.
bulldoze all of it, right? Yeah.
So when
Vern,
you're
did that
doing
in?
those,
Yeah.
one question too is if you're doing those, then do you still have to give them like that 10-day right of refusal thing? All that paperwork still happens in those?
Yeah.
Yep.
Okay.
Yep. All of it. So you'll use the addendum, the CIC addendum, the receipt, all the documents. Yeah.
Katie, did they get rid of the 3-day right of rescission?
Nope. They did not. It still exists. Yep.
But it's a different form that you may or may not use.
Right.
Okay,
Exactly. So, and I'll
that's good.
talk about that a little later. Yep.
That's what I did. I just did one yesterday. So,
Yep. Which is fine.
okay.
One of the other exemptions is non-residential only communities. So I don't know if you guys have them in our area, but we're seeing them more and more where there's storage units, right? Not meant to be lived in, but they're storage units and you own the storage unit, but you don't own the land. Okay.
A lot of those.
Those are exempt from these rules that I'm going to talk about. Okay.
Even though they have associations in them?
Even though they have associations because they're non-residential. If any of them change to be residential, like if somebody builds a house piece with it, then it becomes residential. Then my guess is it's going to go through the courts to determine whether or not it falls under this statute. Now, as
How
an
do you
agent,
know they're non-residential? What defers or determines whether, because they're being used for residential
zoning.
purposes.
Yeah. So zoning is going to determine if it's non-residential.
They could be residential even though they're just storage units, correct?
Right. Yep,
Okay.
that's exactly. So your first step
Okay.
is going to go look at zoning, see what zoning says. If zoning says residential on there, not agricultural, right? Not commercial, if it says residential, then the next step is you need to see if there's any dwelling units in any of those storage units. If there is, then it would fall under this statute. If there's not any dwelling units, then it will not fall under the statute. Caveat to all of that. An association, your buyer is still buying into an association, even though they're not living there, right? Just like restrictive covenants, they need to know the rules. So I would still go through the process of making sure they have all the documents. The 10-day right of rescission doesn't count for those. But you can write in a 10-day right of rescission into your purchase agreement, make it contingent on it to protect your buyer. Right? So while legally this statute won't apply to those storage units, to protect your buyer and your client, you should still be following a process similar to this. Okay.
So if I use that addendum to a CIC for just the storage unit, would that count for their 10-day right of rescission? Or do I literally have to write it in the PA?
I would say you have to write it into the PA because the CIC addendum actually talks about the statute and what's covered, and on the CIC addendum it has what the exemptions are, what properties are exempt from this rule. And so I would use the other category in the purchase agreement or an addendum, and I would just write my own clause in there, making it contingent. Mhm. Yeah. And if anybody disagrees with me for some reason, like you can say something. Just FYI. I'm not all Marv can tell you I'm not always right.
But she's always in charge.
For now. Perfect. Okay. You need a lot of documents for a CIC. It's different than restrictive covenants. Restrictive covenants don't have an association. They're just rules that are a part of the deed that everybody is supposed to follow. There's no association or fee associated with them, right? CICs are very different. There's fees associated with them. There's a hierarchy structure to a common interest community. Therefore, you need lots of documents, right? And we'll go through each one of these. Not long. I'm not going to go through line by line, but we'll go through all of these. And then optional is the modification or waiver of the buyer's right of rescission. Okay. And
So
we'll go through
to
that
open
one
up a
too.
can of worms,
Yes, go ahead.
okay. So on my personal cabin
Mm-hmm.
that's in a campground,
Mm-hmm.
does not have a CIC. You own the structure, but you don't own the land.
Okay.
So when you list it, how would you list something like that where you don't own any land, you don't have a common interest community ownership in the shared parts of the association ownership,
Mm-hmm.
but yet you have use of it. So what would you, in that circumstance, what would you need to put on the MLS for documentation?
So that might be one of them that we can't put on the MLS anymore.
Okay.
So, because in that situation, you don't own an interest in
Right.
the person who owns the land. You're essentially paying rent or
Yep.
paid them an upfront amount for rent to be able to keep your cabin on there. Even though sometimes the cabin is a permanent structure, you don't intend to ever move it. It's
And I
never
get
meant to be
taxed
moved.
on it every year
And you
through
get
the county.
taxed on it. Yep, because the county's great. Christine, I know you guys in Alexandria have been dealing with things like that recently. Any
Have,
ideas you
and
can give Terry?
they've been putting them just under vacant land. And if you get flagged on it, then you get flagged and have to pull it off. But that's the route we've been going with those for now.
Yeah.
Okay. So I know Brandon's in lots of talks with the MLS about those.
Yes.
And there are those too, right? So like that would be an exemption from these rules because there is no CIC. I
Right.
own the land and I just give Terry one of my bundle of rights to put his cabin on it. That's not an association. I still own everything, right?
Mm-hmm.
Hmm.
I just want to
Great
make sure
question.
so that if I do list it, then that you've got some idea. The thing I'm running into right now is we get a lot of I get a lot of questions about, well, how much land comes with it? And you explain to them over and over and over again, there is no land. You don't own
Right.
anything, and it would be written up on a uh, just a bill of sale. That's how you convey
Hmm.
interest, and then you present that to the county and meet the owners, and that's about it.
Okay. Vern, do you guys have anything like that in your guys' area? No,
It's
not
not,
really.
I mean, we don't have anything in Crosby. Like I don't think there's we have some townhomes on the end of Serpent Lake, but that's those where you buy it, you own the land under it. But
Okay.
yeah, there's nothing here that is. This is the first thing I've seen is in Cross Lake where I went there and I'm like, oh, you don't even own the land under the building, and typically that's what I usually run into is you own just the chunk,
Right.
like a 30 by 30 lot or whatever, and the rest is common area.
Right. Yep. So, and I think more and more we're seeing more of these off-brand CICs. I'm going to say quote CICs, right? But these off-brand communities. Um, we'll see how long they last and if the state comes down with more rules. Okay,
Yeah, it's no different than a seller coming to you that has a mobile home in a mobile home park and wants you to sell.
right.
You know, you're literally only selling
Right. You're selling the building. Right.
the building only. Yes.
Hmm. Okay. The CIC addendum to the purchase agreement. Whenever you sell anything in a CIC, this needs to be attached to the purchase agreement. Don't forget to mark it on page 9 of the purchase agreement saying that this is attached. This is just information. This gives the buyer and the seller all of their requirements that is required of each of them under the statutory notice or the statutes that Minnesota has put into place, right? It contains a complete list of the documents right down here on 1 and 2. Okay. It outlines the buyer's right to cancel and right of rescission, tells all of those things. So if you ever have any questions about what exactly you need to do for a CIC and how to do that, this 4-page document, the addendum to the purchase agreement, is going to tell you. The only
How,
place to fill
how are
out
you
any
going to make that page 9 of the purchase agreement when it's already numbered?
No, on page 9 is the big block
Oh,
of documents that you're saying are attached, right, to this purchase agreement. The CIC addendum is one of those check boxes.
gotcha.
Make sure you do the checkbox. That's what I mean. Thank you
Yeah,
for the
yeah.
clarification. The only place that you fill out anything on this particular document is line 26 and 27, but only if there's a master association and this is the first time that the property's being sold.
Mhm.
Okay. So there's 2 different times that CICs get sold. It's their very initial time. So owner owns a resort, they put the CIC together. They're just first offering all these cabins for sale. That's called the initial sale. Okay. So the only time you need to fill out 26 and 27 is if it's the initial sale and there's a master association. And all it's asking you for is the name, address, and telephone number of the master developer. That's it. Otherwise, this is all legalese. Any questions about this one? Okay. On page 4 of this one, I'm sorry, on page 3 into page 4 is the exemptions. So if you're ever unsure whether a property fits, pull out this document and go look through those exemptions. It's going to be the easiest place to find it. Then there are other documents that we as agents have to do, but most of the documents that we have with CICs is we're getting from the association or the owner. One of them is the declaration and or the master declaration, again, for that master association. This is the foundation. The declaration shows to the county and the state that this association is a legal entity. If your association doesn't have this, that should be a red flag because it means that it does not legally exist with the state or the county. Okay. This one identifies common elements. It sets ownership interest for each of the people. and it's recorded against all future owners. Has anybody had an association tell you they don't have the declaration?
One time, and
Yep.
it was a softball team that went together and bought a resort and
Mm,
never, and they divvied up all the expenses, and they never did do anything right. And it was a giant mess
hmm Yep.
because it had
Yep.
been operating for like 20 years that way.
Absolutely. Yep. And that's what happens when I say that if your common interest community doesn't have declarations or says that they don't have them, they've never had them, that's a problem
Mm.
because they are not a legal entity, which also means that each individual owner is legally liable for anything that happens on the property, period. Each individual owner, not the association. So don't let them tell you that it doesn't exist. They might not have a copy. They might need to go to the county and get one. But if it's been around for a while, they either didn't set it up right in the first place, like Marv just said, or it's there. They just need to go find it. Okay. Then here's two more. The Articles of Incorporation. This establishes the association under Minnesota law. It creates the association's corporate existence. Okay. The bylaws show how they govern themselves on a day-to-day basis. Your bylaws are going to talk about your board of directors structure, the member meetings, the voting rights, the procedure, the roles and responsibilities, when they're going to hold voting rights, who can vote on what and when, how you remove directors from your committee. That's what the bylaws are going to have. Okay. So those are the two other documents you're going to get from the association. Then the rules and regs. This is the one that your clients are going to care about. This is the day-to-day community rules established by the association. This one will probably have an amendment or a supplement to it, especially if they've been around for a long time. Okay. The rules and regs are going to talk about your rental restrictions, any pet policies, what their parking regulations are, what color they can paint their outside of their home. The rules and regs are usually the ones that get amended and changed over time, particularly once VRBOs and Airbnbs started becoming more popular. Okay. Another one is any amendments, of course. Now, this is the new one that we're now required to get. The maintenance plan, schedule, and budget. Maintenance plan, the schedule of maintenance, and the budget of what that maintenance is going to cost and how they're going to pay for it. Okay. There is a lot of associations who have gotten into problems with this in particular because they didn't have a maintenance plan, a schedule, or a budget. So the state changed the law, the Minnesota Common Interest Ownership Act. They changed it to include these things. These are now required. Okay. Again, something you get from the association, not something you write up. Now we talk about ones that we have access to, but we don't write up. So remember how I talked about before that there's the initial sale, right? At the very beginning, when it's first broken up into a CIC, there's the initial sale, and then everything after that is called a resale. There are two different disclosure statements. One of them, and please, they call this the disclosure statement, but it's the initial disclosure statement. It's not the seller's property disclosure statement that they're talking about in any of these documents. Why they don't clarify that, I don't know. But this disclosure statement is for the initial sale of anything in a CIC. It's going to have a balance sheet, the preparer's name, projected operating budget, what common elements are, any special assessments. This is prepared by the association or the master association. Not prepared by you, not prepared by the seller. Okay. Most of the time, we will be dealing with the resale disclosure certificate. The resale disclosure certificate is going to have all of those things that the disclosure statement has and more. Okay. And there's two things. One, either the association can already have one, and as long as it has all of this information in it, you can accept that one, or we have one that we can give to the association for them to fill out. Okay. So either or works for the resale disclosure. Oh, I had something else I was going to say about the resale disclosure, but now I forgot. Oh, now I remember. The seller might be charged in the addendum to purchase agreement, the CIC addendum to purchase agreement. It says in there that if the seller is charged by the association, has to pay the association for any of these documents that they're asking for, that it is on the seller to pay for that. Okay. It says it right in the boilerplate language. If the buyer cancels within their 10-day right of rescission or 10-day of cancellation, right? Then the buyer has to pay the seller back for that cost. I haven't heard of any associations charging anything. Maybe they will at some point. I don't know. I would think their dues should cover all of that, but maybe not. But just FYI, it is the seller's bill to get all these documents, including the resale disclosure certificate, which some associations might charge someone for. Because it is a lot of information that you've got to go pull as an association member, right? I get that. Okay. Now, these are my two favorite ones. One is the receipt of the CIC documents, and I purposely left this one till last because it is your cheat sheet. This is your cheat sheet for all of the documents that you need and are able to give to your buyer. If you're not sure, pull this out first. Now, the 10-day right of rescission starts when you or your buyer, as the buyer, you as the buyer's agent or your buyer receive all these documents. Okay. Sending this receipt to your buyer triggers the 10 days. Does that make sense? Yeah. Okay. I love that they have this. I'm not gonna lie, because it's easy check marks. Ding, ding, ding. If there's not a master association, don't click anything on master association. If it's only a resale document, that's fine. This one's either or, disclosure or resale. Again, this is not the seller's property disclosure statement. That's separate. Okay. Then, like Marv alluded to, your buyer does not have to wait 10 days to accept all the amendments and all of the things from the association. They don't have to wait that 10-day period. They can waive their right to that 10 days. There are a couple of reasons why this might happen. One, they have a family member that's already in the association. They already know how it works. They've already read the documents. They don't need to worry about it. Okay. Two, they just want to close. They're just done. They want to close. This is the one they want. They already know it. They'll deal with the association later. They're fine. Three, oh, is that three? Yeah, three. They already got all the documents. You showed this property to them 2 months ago. They weren't sure if it was the right one for them. You gave them all the documents and the receipt at that time. And then the 10 days is already up, right? The 10 days starts when you give the receipt, no matter what. If there's a purchase agreement or not, it's irrelevant. Once you give the receipt of all the documents, that starts the 10 days. Okay. The buyer can't fully waive their right. They have to have at least 3 days. The other thing is the seller and the seller's agent cannot require a waiver with the purchase agreement. That is against Minnesota law. And I will tell you, that's a red flag if they're requiring a waiver. Different if they're asking you. You're on the phone with the listing agent. You tell them, yep, they got all the documents last week. The listing agent says, great, my sellers are going to accept your offer. Do you think we should just do a waiver so that everybody's on the same page? That's a different conversation. To require the buyer to waive their right is illegal. Do not let anybody tell you any different. Okay, questions about that one? No? Pretty easy. We're going to get into the two different right of rescissions and right to cancel in a minute. Oh, wait, I saw Ashley was reading. Sorry. Oh, you're on mute, my dear.
Sorry, there was something about this. The bottom part of it here.
Mm-hmm.
I need to blow it up. What does it say? Buyer acknowledges that buyer has not received association documents.
Mm-hmm.
Because I was missing one and then I went and got it. So I gave him like 9 or whatever it was, 9 out of the 10. I went
Okay.
back and grabbed the last one. That's when the 10 days started. So I think we
Mm-hmm.
used this little thing. Didn't we up here? What does this say up here?
Uh, where?
This part on the
Modification?
second page. Yeah, it's hard to
Yep.
read.
Yeah, it is hard to read. Sorry, guys. So yeah, so this is the modification for the rescission period,
Yeah.
and this is the modification for the right to cancel. There are two different 10-day periods that CICs have, and we'll talk about them in just a minute, but there's two different ones. So this first one here talks about the right to cancel, hence buyer has the right to cancel. This one talks about the right of rescission. Okay. So that might be what you have used.
I think I did because I was, yeah, to waive
Yeah.
the remaining days. They didn't want to do either of those. Yeah, they didn't want to waive the remaining days and they didn't want to modify the 10 days. They were done in 3 days anyways. They got sick of looking at it.
Yes.
So yeah, I
So
think
then, yep. So really I wonder what you should have done was maybe 44 to waive the remaining 10 days. I'd have to know more about the situation and what exactly it was, but I think that might be
well,
what
they
you
didn't want
should
to
have
waive
done.
it because they didn't have the last document and they didn't have a chance to review everything. So they were going to go home that night, review everything,
Mm,
right?
yeah,
So they didn't want to do that. They didn't want to waive the remaining days. They just left it. And they didn't
right.
want to modify it because they wanted to be done. So we didn't check anything there.
Oh, okay. Mm-hmm.
So anyways, it's so confusing, all these little things.
It is. So a whole bunch of little things. Yeah. Hopefully this timeline makes it a little less confusing. Um, Maybe. Before your buyer writes an offer, you're going to determine whether the property is subject to these statutes. Hopefully you just know it's going to be in the declaration if you don't. And you're going to request the resale disclosure certificate. The resale disclosure certificate can be no later than 90 days from the time you write the purchase agreement. Okay. Within 10 days of getting that request, the listing agent getting that request, the association has to furnish the resale disclosure certificate to whoever's asking for it. Then, when you make the offer, you're going to attach the CIC addendum to the purchase agreement. Okay. And within 10 days of receiving docs, and this piece here can move, right, in different places, but within 10 days of receiving the documents for the association, including the resale disclosure certificate, buyer has the right to cancel the PA or the right of rescission. Okay, and we'll talk about those in just a minute and what the difference is. Before closing, all association documents need to be delivered to the buyer, right? Which is that 10-day period. At closing, any regular assessments need to be paid by the seller. Or if you've chosen something different in the purchase agreement, you need to watch these things. Post-closing, seller's just going to pass on any written notice of potential special assessments, any notice they get from the association that they're not supposed to get, right? And with this timeline, it seems really easy, but your file is this flippin' big. I think that's the hardest part is because there's so many documents that you need to
Yeah.
make sure that they get. That's the hardest part of this.
Can you send this out on a PDF so we can print it off and stick it in my folder? So I need to pull it out when I need it.
I have a one-sheeter ready to go. Yes.
All right, thanks.
Perfect. Okay. Now we're going to talk about the two 10-day rights. Where are we for time? I'm not even looking. Okay. I'm
15
going to go
minutes
through
left.
these quick. Perfect. There's two 10-day right of rescission, right? Well, there's a right to cancel and a right of rescission. Okay. Most of the time, both of these are going to happen at the same time because they're getting all the documents at the same time. The buyer can rescind their offer within 10 days after receiving the disclosure statement. Remember, this is the association written disclosure statement. This is not the property disclosure statement or the resale disclosure certificate. Okay. They can rescind within 10 days. The waiver for this is only valid if signs as a separate legal instrument after 3 days. So you have to sign the waiver 3 days after they get the resale disclosure, otherwise the waiver's not valid. Okay. Questions? Any questions? Okay, that one seems fairly easy. The 10-day right to cancel. This is the one that we normally think of when we think of that 10-day right. Is the full document package. After they receive that full document package, they can cancel the purchase agreement without penalty. Okay. And that's all of those documents that are on the receipt. Now, I say that we usually don't even know that there's two different 10-day rights because they're usually happening in conjunction. You're sending the resale disclosure with all of these documents as well. And so they're happening at the same time. But then if you go back to that waiver, it talks about the two different times, the two different 10 days. Okay. This one here talks about the amendment to a disclosure statement. So say you get the disclosure statement from the master association and then the master association amends it before closing, you get the amendment. The buyer can waive their right to go over that amendment. That's what this one's talking about here. For the disclosure statement. This has nothing to do if they amend the rules and regulations. Okay. This waiver and modification at the bottom is talking about the association documents. Okay. And it talks about the right of rescission on both. Okay, questions there? Or does that make sense? Yeah, I see Christine nodding. We're okay? Okay. I always worry when nobody has questions. It's either I've explained it so badly that nobody understands, or I've explained it so well that they're like, oh yeah, got that. We're good. I usually find out afterwards when I get phone calls. So don't hesitate to call me if you have questions afterwards. Okay. Couple things that you also need to know. Amendments, exemptions, and assessments. We talked a little bit about all of these. Material amendments, if there are any changes to the disclosure statement, the association disclosure statement, not the seller's disclosure statement, those are different rules. The buyer can cancel within 10 days, okay? Amendments have to be disclosed promptly. Assessments and exemptions. Exemptions are on that addendum, right? Don't forget to look at that if you need exemptions. Seller pays regular assessments up to the closing date. Special assessments are governed by the purchase agreement terms. So when you're filling out that taxes area in the purchase agreement, you need to look at what you're checking. We check all the time, buyer shall assume instead of seller shall pay, which means buyer might have to bring a whole bunch of money to closing, especially if they're getting a mortgage to get that 6 months of taxes and insurance and association fees into their account. Okay, so watch that. Replacement reserves. So sometimes the association asks its members to give extra money once a year, twice a year, something like that, with the understanding that this will be used for future special assessments, future maintenance, all those things. Okay. Those reserves that the seller has put in are included in the selling price. They are not extra. Buyer doesn't, it's not like propane in the tank, right? You don't have to come to closing with a check for the seller. Those are included and the buyer gets them. It goes on the buyer's account after that. If your seller or your buyer wants something different, make sure you put it in the purchase agreement. Oh, my phone's. There we go. Okay. I hit you guys with a lot of stuff. Do you want me to go over the red flags? I have 3 slides of red flags that you should watch for. Or do you want to ask questions? Ashley says yes. You want to ask questions? You're good? Okay. Stale or missing resale disclosure. So now your buyer can close on the house without receiving any of these if they choose to. That's their choice, right? However, if the resale disclosure is a year old, finances of an association and the rules of an association can change monthly, right? That resale disclosure needs to be dated within 90 days of you receiving it. The other thing you need to look at is underfunded reserves or no maintenance budget whatsoever. That is a big red flag because that can be a big dollar amount out of your seller's pocket or an assessment later. Okay. Pending or recent special assessments. This is no different than special assessments on a home, right? If you know that curb and gutter has just been put in the property that you're selling, you're gonna go look at what those costs are for your buyers. It is no different in an association. You're just looking at different special assessments. Okay. Very old or missing governing documents. So you remember when I talked about the declaration and why it's important to be able to get that because that determines the legal entity status, okay? And it needs to be recorded. Those are important. Usually your declaration, your articles of incorporation are going to be fairly old, depending on the common interest community and where you're going. So as long as they're there, you're fine. Your bylaws and your rules and regs, they should be amended once every 5 years, right? We change as a culture, the people in the association change, the rules change versus Lakeshore and blah blah blah. Like they should be amended on a regular basis. If they're stale, that might be a problem. If there are any unpaid assessments, delinquent regular assessments, any unpaid assessments that could signal financial distress for the association. And if the association has to file bankruptcy, what happens to the common elements of the property? right? Okay, so make sure you're looking at if there's any on their balance sheet, if there's a bunch of delinquent special assessments, meaning other owners have not paid into their special assessment pool, that's a problem. Master association documents, if you know there's a master association, but they don't have the documents, that's a problem. Okay. This one's fun. Litigation or lawsuit history. If your association has a bunch of litigation or a lawsuit history, and you can do a quick Google search to figure that out, that could be a problem. Your buyer could be signing on for being on the hook for something that the court has decided because of a legal dispute from the past. Okay. Or there could be more coming. We had an association up in Lake George who the president and the vice president, unbeknownst to anybody else, sold a portion of the association property to a neighbor. That neighbor then clear cut that whole swath all the way down to the lake, which is a huge no-no up here. And the association itself was in a lawsuit for 3 years. Okay. Any deferred maintenance, which should be a red flag for any property we're selling. We're looking at the siding, we're looking at the roof, we're looking to see if the pool has been taken care of, right? In an association, we're looking at not only the building, but all of the other common elements there as well. Okay. Surprise restrictions. If there are surprise restrictions that haven't been disclosed on the MLS, but as your buyer is going through the rules and regs, they find a restriction that they're like, I thought they told us we could have 3 dogs, but this says we can only have 1. That could be a problem. It either means that their bylaws or their rules and regs are not updated to the current what everybody has agreed to, or it could be that they're just not following them. And if they're not following that one, what other ones are they not following? And then this is the biggest one, pressure to waive your rescission rights. If a listing agent or a seller is pressuring your buyer to waive that right of rescission and the right to cancel at any point, if they're pressuring you, or that's a problem. That tells me there is something in there that is a problem that my buyer's not going to like. Okay. You guys are really quiet today, but I know that was a lot of information, so I don't blame you. Um, and I had to brush up myself on all the pieces of the CIC stuff. How many of you never want to sell a CIC ever, 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 ever right now?
It's not that bad, honestly.
It isn't. It is a lot of documents. And like I said, Remy, like I used to take the documents home with me in a little packet, and that would be my reading for that night, right? Go through and just check and make sure there's nothing glaringly terrible. Remy is a godsend for that. You can put the association documents right in there and then just ask it. My buyers are worried about this rule. My buyers are worried about this. Where do I find it? What are the rules governed with it? Right? Can you rent out this property? That's the other question we get from buyers. Hmm. Okay. Any other questions? Or are you guys over CICs? We're done. We don't want to deal with them anymore. No one should ever sell them again.
One thing I can say is that very often you'll sell property within the same CIC over and over again. So once you've read through all of the minutia, then you don't have to read it again, unless it's change, of course. But it really is not a whole lot different than selling a house, other than you have to have all your documents in order. And if your listing agent doesn't do that for you, then you got to get it.
Hmm. And you have every right as the buyer's agent to contact the association directly.
Yes, yes.
Every right.
Yeah.
If the listing agent is not getting what they're supposed to be doing, call the association. Go knock on the association door, whatever you need to do.
And part of the MLS includes the association president's phone number so that the
Mm-hmm.
buyers can contact them themselves.
Mm-hmm. Mm-hmm. Yeah. Associations really aren't that bad. And Marv is absolutely right. Usually, if you do a good job with making sure that the new buyer coming in knows all of the rules, all of the pieces, and they come into the association ready to be a part of that community, you will get more listings because that association will talk at every association meeting how wonderful this agent was and how terrible the other agent was, right? You
Yeah.
will get more listings because of it. So if
Yeah.
you put the time up front into any new association, it will benefit you in the long term. Just like with anything in life, you put the time up front. Okay. Okay, I'm 1 minute over. Thank you guys so much. I know that was a lot of information. Hopefully that brings a little clarity to CICs, what documents you need, all those wonderful things. Next week on Wednesday at 9 o'clock, we are doing our mastermind that we're going to talk all about scammers. I want to hear your stories. I want to hear how you figured out they were scammers, how you figured out if you figured out how to list the property anyway, all of those, not for the scammers, but for the actual seller, right? I want to hear all of that. So I'll see you next week. Have a great week, guys.
Thank
Bye bye.
you.